I am on record here having said that in Zambia we have what is called the Statutory Functions Act. The Statutory Functions Act gives direction as regards who should perform a statutory function. Even collecting views from the Zambian people requires that you must be mandated by a piece of legislation for you to do that. Even to put together views that people have put out, you are required to come up with a particular piece of legislation that will allow you to do that. You can't just wake up and say, no, we've collected these views, therefore we are going to do this. And with the utmost respect, I have listened to my colleague, Mr. Simue, who says that the government it's not the government that is amending this law. I think this thing of the amendment of the law is an agenda of the UPND and not the government. The government, of course, occupied by the UPND, is not the one that is amending this law. There's just an agenda of their own. If they could only respect the wishes of the people who are the owners of the document, I don't think we'll have a problem. Andrew, you can't tell me that civil society is saying no to this. You can't tell me, lawyers are saying no to this. Zambian people are saying no to this, but the government is saying, or the UPND government is saying, we are proceeding. On what basis are you proceeding? There is a problem with what is going on here, and we have to admit that. And that will be the first step in us going forward. Those views that they are saying were collected from wherever and the commissions that were put together were protected by pieces of legislation. What piece of legislation protected the process of putting together these views? There is none.
Mr. Simue, number of issues.
Let me start with my colleague Melissa there from Livingstone, where he asserts that what is being done is unconstitutional. But you see, what they are failing to do is to quote which part is unconstitutional. Even the word legitimacy, which is referring to that, if the process under Article 79 is not legitimized by wide consultation, then it's unconstitutional. There is no such a provision in the Constitution. I would want to challenge them to give me such a provision. Then secondly,
maybe I should intervene. There's a danger here. Mr. Simue cannot lecture us about the law.
We are debating. We are debating. We are debating. We are debating. Listen.
Let him finish his submission.
Let me finish my submission.
And then you're going to react.
Yes. Let me finish my submission. People are watching. Okay? At least with the constitutional law that I have done at the University of Zambia, I know that Zele does not have a constitutional law. So what he did is what I did. So let me say something, okay? That the idea to talk about legitimacy and in the manner that he has presented it, that Article 79 has no express provision for legitimacy. I just referred to it. And I was saying it provides for alteration of the Constitution. And when you are legislating, the process of legislating is provided for in terms of publishing in the Gazette. It's a procedure which is provided for here. 30 days before the first reading. How the second reading must be done. And Article 62 of the Constitution of Zambia vests legislative powers in the National Assembly, in the legislature, not in another person. When we may refer to the preamble of the Constitution and say, we the people of Zambia, even if all of them have not participated, we will still refer to it as we the people of Zambia. That's how it has been. Now, my comrade here talked about us collecting views minus legislation.
So this is
I want to say this. Yes. The Inquiries Act, for a very long time, has been used, starting from the one-party participatory democracy, to collect views by the president, even if the Inquiries Act itself does not provide for an express, or does not provide an express clause for constitution making. All these presidents that we have had, the Mwanakatwe, the Mvunga Commission, 1999, all these commissions that we have been born because of the Inquiries Act. That is a piece of legislation. Now, in terms of what we are looking at, we know that the ones that initiate bills to Parliament is the executive, not another person. So the question that we need to ask ourselves is that, At what point has the law been broken? Our argument is that there is no law that has been broken. And then to assert that this is a UPND agenda is a pure misdirection. Because in the provisions, you are not going to see UPND anywhere there. In the provisions of this particular bill that we are reading. Except if he admits that he is pushing for a PF agenda himself. Based on the law firm that he comes from. Now, then we will have lost the argument.
What has the law firm got to do with
then we will have
my position?
Let me finish.
No,
unless you want to be moderate,
you've made an allegation.
Respond. Now I'm saying
you can't make allegations.
So here is the allegation.
I can't be guilty by association.
In the same manner that the comrade wants to make UPND guilty, by merely think, because there is UPND and the executive. The executive have a constitutional mandate to take a bill to parliament. That is a fact, in black and white. And it would help the viewers more when we say if legitimacy is lacking in the alteration of the constitution, then this particular process is unconstitutional. It will help our viewers who are listening to us now for them to quote the law which says that. Because the strength of every lawyer is to know where the law is found, not speaking in passing. So when we say they are using the argument of the jurisprudence of constitutional making process, we are saying there are theories that are not enshrined expressly in the law in Zambia. That's why you find my learned colleague there went as far as Kenya and so on. You use such arguments from outside our jurisdiction for persuasive purposes. But they are not backed, those views, by the Constitution of Zambia, which we need to hold sacred at all levels when matters of this debate begin to emerge. So now I challenge my two colleagues who want to educate Mark to quote in no uncertain terms in the Zambian Constitution, where it provides that in the absence of legitimacy in this particular process, in which government has a clear constitutional mandate under Article 79, then the process is unconstitutional.
Councillor Malisa,
answer that, Andrew?
Councillor Malisa, yes, do you have an answer to that?
Yeah, okay. So I'll pose a question in answering what my colleague Mark has said. When we're talking about legitimacy of the constitution making process, right? If you are going to tell me that I have to cite what is in the Constitution, then I'll ask you to say, where does the Constitution come from? Parliament or the legislature or the National Assembly is a creation of the Constitution, right? It's created by the Constitution itself. And when the National Assembly, or should I say Parliament, is exercising legislative authority, it is exercising legislative authority on behalf of the people of Zambia. That is why we have what is called constitutional supremacy. For example, let me go to Article 61, which says the legislative authority of the Republic derives from the people of Zambia and shall be exercised in a manner that protects this constitution and promotes the democratic governance of the Republic. Right. So Parliament does not have carte blanche. Just because it has authority to legislate, it cannot just make legislation willy-nilly, right? The legislation is confined to what? To protecting the Constitution and also to promote the democratic governance of the Republic. Just by reading Article 61, as a matter of principle, it will tell you that any amendment or anything that you want to do, any legislation that is outside the constitutional parameters or that has the potential to mutilate the Constitution automatically becomes unconstitutional, even if it is an amendment of the Constitution itself. It also follows that any amendment that threatens the democratic governance of the Republic is also unconstitutional. I'll give you an example. Even if you say that the National Assembly or Parliament has got powers to amend the Constitution, yes, it has, but there are certain amendments that can never happen. If you read constitutional jurisprudence or what you are calling theories of constitutionalism, that is where these constitutional documents come from. They come from those theories, those doctrines. There's what we call the basic structure doctrine, which was developed by the Indian courts in 1973. The basic structure doctrine demands that Parliament when it's making constitutional amendments, cannot make amendments which alter the basic structure of the Constitution. For example, Parliament, in as far as it has powers to amend the Constitution, cannot wake up today and amend the Constitution to remove the executive and say, oh, today there will no longer be a president in the Republic. You get what I mean? Such an amendment, even if Parliament has got power to do that, from a theoretical point of view, Parliament has power to make any amendment. But from a practical perspective, it is not possible today for Parliament to wake up and say, we're making an amendment to say there will no longer be a National Assembly of Zambia. It can't happen, right? But Parliament has the power to do that. So what constrains Parliament is what we're calling the basic structure doctrine. And any amendment that is made has to fit within the constitutional parameters of the country. So it is not enough for you to just start saying, just because Article 79 allows Parliament to amend the Constitution, then the Parliament can make any amendment. That is wrong, my brother. That is wrong. So whenever Parliament is exercising its legislative mandate, number one, it is exercising that legislative mandate on behalf of the Zambian people. And then number two, that manner is restricted to what protects the Constitution and promotes democratic governance. So if I raise an argument that the amendment that are being proposed are not protecting the Constitution, then I have a legitimate claim to call such amendments what? Unconstitutional, including ignoring the basics of what? Of public participation, because the Constitution is the people's document. And it follows that because the people are the ones who created the Constitution, they're the ones who created the same Parliament. The same Parliament came from the people. So it follows that if anything that is supposed to be changed, then the same people are the ones who should say, we want to change this. So I wanted to correct that assertion that Parliament, because of Article 79, can make any amendment. That is not possible. And these theories that you are calling persuasive are actually the cornerstones of constitutional governance. If I'm going to talk about separation of powers, which part of the Constitution mentions separation of powers? It's not there. You can look the whole Constitution, it is not there. But it is a constitutional doctrine that is sitting in that Constitution, even if it is not expressly mentioned. So some of these things that we talk about are not expressly mentioned by any article, but they are sitting in the spirit of the Constitution and anchor or at the bedrock of what the Constitution is all about. So please, when amending the Constitution, Parliament does not have carte blanche. That is not correct.
Let's get to the first caller that we have on the program this evening, before we can get to Article 52 and why it must be amended or why it might not be amended. Good evening. Thank you so much for joining us on the program tonight.
Good evening, Andrew. How are you?
I'm very well. Who's on the line and where are you calling us from? Also, are you able to indicate to me which channel are you watching this program on?
I'm watching on the UPN Zambia.
Okay.
Yes, this is Comrade Mukosa. I'm calling from within Nsaka. Good evening, our guests there.
Good evening.
Good evening, Mukosa.
Yes, I think the what I have is that even when we are trying to do a right thing, we always want to bring in politics. That is the worry I have. Because when you look at the clauses that are being debated or the clauses that are being proposed by the government, I don't see anything wrong with us to come up with those, to put up those rules, to guide ourselves how we can govern ourselves better. I don't see any by the master today to say these amendments, it will reach the dictatorship. And when you ask him there to say which clause that will bring dictatorship in this country, I don't think he can mention one. But it is because he's looking at these issues using political lenses. Let us allow ourselves to put laws that will better our nation. What we need to remind ourselves is we enact laws that will better So for me, as long as these debaters, most especially those who are against.
All right, thank you so much, Oscar Mkosa,
Right.
for that contribution. Gentlemen, let's get into the amendment. This is amendment number 2. And allow me to quote the Constitution. I'll go to Article 52, Part 6 of the Constitution. And it reads, where a candidate dies, resigns, or becomes disqualified in accordance with Article 70, Article 100, or Article 153, or a court disqualifies a candidate for corruption or malpractice after the close of nominations and before the election date, the Electoral Commission shall cancel the election and require the filing of fresh nominations by eligible candidates, and elections shall be held within 30 days of the filing in of the fresh nominations. This was part of a huge debate that arose in Bill 10, and also is part of a huge debate that has arisen in this Bill number 7. Stakeholders have submitted, others have submitted that we need to address the ambiguities of this that when a candidate resigns, then we need to cancel the elections, and the Electoral Commission of Zambia, obviously through the powers that it has been gifted, will call for fresh nominations. Don't you think, Council Zimba, this is a problematic article that we ought to deal with, especially before we get into the next election?
Okay, so let me start from this angle. I think there's a growing tendency in this country that what you will see is when someone has a contrary view, then they are looking at the matter from political lenses. I've said time and again, even on this program, I'm not a politician. I must not be associated with politics. I'm a lawyer, I'm a professional, and I'm trained in that regard. So the views that I hold are as a result of convictions that I have from my training. Now, when we look at Article 52, and in particular relating to the issue of nominations and withdrawal of these nominations and all those things, the provision itself does require an amendment, but not in the manner that it is being done. We need to find a place where we can agree as a country in terms of how we proceed. So we need to first of all say, if this particular provision is problematic, how best can we deal with it? For example, in Bill number 10, and in particular Clause 11, the proposal was to repeal the whole provision. Okay? In this particular Bill number 7, the proposal that is there is something that does not promote democratic tenets in the country. First of all, the proposal is that if a person pulls out of the race, what do? Forget about them, proceed with this particular matter. I do remember that there was a matter involving withdrawal of candidates in the Kavushi by-election. And the Constitutional Court made the position clear as regards the application of this particular provision. And what the Constitutional Court said in that particular case was that if the person that has withdrawn is an independent candidate, then the election should proceed. For the reason that there is no political party that is going to be defranchised or suffer any prejudice by not having a candidate participate. But in a particular case, if it is a political party that has a candidate that either dies, resigns, or withdraws from the race, the understanding, and when you look at the report that was presented by the technical committee that was drafting the 2016 Constitution, was that there must be room to ensure that political parties have representation and contest in these elections. Now, the manner that is proposed in this particular case does not promote that principle. We need to find middle ground. How can we do this? And for us to find that middle ground, we need wider consultation on this particular subject. If we don't have wider consultation on this particular subject and we proceed in the manner that we want to, it will be a problem. Again, I have heard stakeholders argue that there must be no challenge when it comes to nominations. Once nominations are filed, we don't want a person to challenge those nominations. In this country, the case of Mbua versus Mandi, I think that is a 2018 decision. The position was made very clear that you can challenge, but after you have challenged, there is no appeal. You see that? Now, it is all right to provide for that in that particular manner. The position of the law is very clear. So we must not rush into getting to do what are called knee-jerk amendments for convenience. But we must be able to find a way of getting to middle ground in terms of how we address these issues. Because these particular provisions have an effect and an impact on now and the future.
And the future.
And what kind of document do we want to have? It is the people that must tell you that this is the kind of document that we must have. It must not be the executive or people in government who must be able to say this is the document you must have. I have said time and again, politicians must not be trusted with the constitution-making process. Never.
Speaking about politicians, Councillor Malisa, the president had, made comments over this particular clause, and he made it very clear that this clause has potential to allow a sitting president to remain in office beyond the constitutional 5-year term, and that's the reason for why we must deal with the lapse or the gaps that are in this, particular, constitution. According to you, do you think, the president was spot on when he made mention that we need to deal with this issue because it might have an effect on a sitting president who might serve, years beyond what is in the Constitution?
I agree on the need to sort out this issue, just like what my colleagues are saying, that the issue needs to be sorted out. But as to whether someone can stay in office for years beyond what is prescribed in the Constitution, I respectfully disagree. The starting point is we have had 2 elections with this Article 52(6) in place, including the election that brought the current president into power. This Article 52(6) was there. Used interchangeably, because candidature in an election is not an office that you can resign from, right? You can't resign from being a candidate, but you can withdraw from being a candidate. So the court went on to say that resignation as envisaged under Article 52(6) refers to resignation from a political party, right? So what it simply means is that if I am nominated by a political party as a candidate, and the political party is sponsoring me to be a candidate, and then before the election or after close of nomination, but before the election actually takes place, I resign from that political party. It means I'm no longer a member of that political party. Then it means I can't represent that political party in an election. Then naturally that political party has to find someone to replace me. That is the rationale behind this Article 52.6. So now, there has been some conspiracy theories that some people will be resigning from their political parties a few days before the elections so that they delay the election. Okay, you will delay the election by 30 days because the Act says, the Constitution says the election has to be held within 30 days, right? Is 30 days yes? No, the answer is no. But what I'm saying is, if such a situation happens, we have courts in this country who interpret the Constitution, right? And the doctrines that my brother Maximo doesn't like, these doctrines that us constitutional lawyers always talk about, these doctrines come in even the way the court reads constitutional provisions. So we can actually take this Article 52.6 if it so happens that a presidential candidate sponsored by a political party resigns from the election. We can actually take it to the court and say, court, read this article and tell us what is supposed to happen. I doubt that we can ever have a situation where we are going to have years and years without having an election. I don't know I don't know how many political parties we have in this country, and I don't think we can have 200 presidential candidates withdrawing, or not withdrawing, because if they withdraw, that's their own problem, resigning from their political parties. Then what kind of presidents are they? So I agree that the way it is crafted, it might need some working on. That is not even in doubt. It's not in dispute. The Article 52.6, it was made with good intentions. The people who wrote this article were not envisaging a situation where we're going to have irresponsible people heading political parties. That is not what they had in mind. What they had in mind was people who are genuine. And I think the intention was that under genuine circumstances where an unfortunate event happens, like a death, or someone resigns from the political party does not have any representation, it will need a replacement. So it will be unfair even for the ruling party. See, these things we have to look at them. Any party, let me say the ruling party or any other party contesting in any election, and in the manner that the amendment is crafted, it's saying that if someone resigns, then the election will just go on. Now, what if 20 people or 20 candidates resign from their party for whatever reason? Right? They resign. Then that party will be disadvantaged because it will have lost 20 candidates due to no fault of its own. So a balancing act has to be struck here to say, how do we sort out this problem? And I think the answer lies with the courts. If such a situation happens, we have to take it to court and let the Constitution be. Let
me bring in Mr. Simuyo on this one. The election date for elections, presidential elections, already prescribed for, in our Constitution. When we have situations where continuously candidates are resigning, does that have a potential to cause a constitutional crisis?
Yeah. So before I deal with that, I think it is important that I contextualize things by first of all responding to my brother Jonas and Melissa. In the first place, you know that we have sources of law in Zambia as provided for under Article 7. So if it involves amendments, we must refer to the law. And among the sources of law we have in Zambia is case law. Case law. Now, I'm glad that they made reference to very specific cases, which I also want to do. You may recall very well that there's a 2022 case, should be Isaac Mwanza, this is the Attorney General, and this is ECZ, on the issues of resignation, which now prompted the Con Court to make a pronouncement, which is now law. What happens when someone resigns? And then there is a Stephen Katuka case in which ECZ had contended that the candidate did not notify the Electoral Commission of Zambia in writing, and the court ruled that it was immaterial in what manner the resignation was made. the candidate did not need to prescribe the manner in which the resignation could be made. What I'm trying to say is that this provision under Article 52 has been a matter of constitutional court contestation, and it is very clear. Number one, it talks about the resignation, dying, or becoming disqualified in accordance with Article 70. Under Article 70, what did we find? We find qualifications and disqualification of one to be a member of parliament. Then it says, comma, Article 100. What did we find there? Qualifications and disqualifications of one to be president. Then it, or 153. What do we find there? We find mayors, council chairpersons, councillors. What this basically means from those judgments, like the case I referred to, the 2022 case, is that any of those decisions here can cause an election again for the president. There's no withdrawal here. For the president, for MP, or for mayor, council chairperson, or councillor. That said, let me indicate that from whatever angle you look at it, you can go to court if there are express provisions on who has legislative powers, which here Marisa has admitted. Legislative powers vested in the National Assembly under Article 62. Going by his line of theories, go in line with representative democracy. Because democracy is in two phases. There's direct democracy, there is representative democracy, where you exercise certain decisions through your elected officials and then under the circumstances, members of parliament. They have a clear constitutional mandate. No argument about it. So the argument that we have is that, number one, there is no law that has been broken and the debate is done. And what we have been struggling, you will have a problem when I am debating with the learned colleagues who cannot cite the law as to support their argument. We can use all those persuasive ones, theories. They are not discarded in their totality. They are very important when it comes to constitutional making processes. But where there is an express provision, we stick to the strict rules of the text. And the strict rules under the circumstances is Article 79. What else? Article 62. Making reference to where the Constitution says this Constitution is derived from the people. That is correct. But that does not make people legislatures.
The President is of the considered view that if we don't work on this article, it might lead to a sitting president serving for longer.
Now, I want to substantiate, though the court has not yet made a pronouncement, because a particular legal thought only becomes enforceable when, under the circumstances, there's a pronouncement. What we will give on that particular level, in regard to the point that you have raised, will be just legal opinions. Do you get the point? So, what would happen afterwards? We have no case law that has answered that question. But we can give legal opinions, and to every law there are two sides. In my lecture, Professor Vunga told me, to every legal argument there are two sides. So they have a side, we have a side. And our side is that based on the ruling of the Concord under Article 52(6), the court is very instructive. You resign, you go back for fresh nominations. Case law is one of the sources of law in Zambia under Article 7 of the Constitution of Zambia. We can't run away from it. In other words, there is already a decision made by the court on what happens when one resigns. What they are going to, they will get all the cases. There is no latest case that beats that one at the moment. That case has never been overturned. The fears that we need to avert now is the implication of that judgment, Andrew, which has necessitated fresh nominations. And there is a president here under Article 100. There are MPs here under Article 70 mentioned. There are also mayors, council chairpersons, and councillors mentioned in the same clause you are looking at. So we cannot discuss presidents in isolation because Article 100 is very direct to presidential candidates. So for me, I would want to narrow my debate to the strict rules of the text, notwithstanding the importance of the theories that are fundamentally critical in advancing legal argument on constitutional making processes.
Councillor Zimba.
Now, the question that you asked me, that the date is statute bound. Now, this is the implication of the judgment, okay? Because when the court makes a ruling on this particular matter and interprets the law in a certain manner, the interpretation sometimes may even affect other provisions. And now the question you've asked, we need to go back to court. That's a procedure, he knows. What will be the implication of this judgment on that clause? For us to be conclusive in our conversation, the court again must make a pronouncement. Otherwise, it's a double-edged sword, and that's what we are saying. So if it's a double-edged sword, we can remedy it by doing away with the mischief that has been provided.
Councillor Zimba.
I think I needed to give an indication.
And as you give an indication, do you think this piece of legislation might lead us to get into a constitutional crisis, especially that the date for the election is already prescribed for?
It can't. When you look at Article 52(6), in the event that you have a situation where there's resignation of a candidate from a political party, nominations will be conducted, and within 30 days there must be an election. There's no constitutional crisis. There's provision at law. I have listened to Mr. Simue talking about he wants to stick to the strict text. The strict text does not start from Article 79 that he's talking about. In our constitution, there's legislative authority. Legislative authority starts from Article 61. Article 61 will tell you that legislative authority derives from the people of Zambia. Okay? The people of Zambia are the owners of this document and are the owners of those people who are going into parliament as members of parliament. They are the ones that are giving the authority. And in exceptional circumstances, such as when it comes to the constitution, when you look at the preamble is telling you that the people of Zambia are saying, we the people of Zambia. This is the text. And these people who are saying, we the people of Zambia, are saying, don't touch our document without our input. And if that is what they are saying, why is it that you want to touch their document and tamper with it without their input? It is not allowed. It is not a question of principles, but it is a question of things that work and things that are contained in this particular law. I have listened to Mr. Simue tell us that case law is part of the sources of law. And look, the Constitution in Article 7 is telling us about the laws of Zambia. That is the marginal note. And it tells you what this comprises of. There is the Constitution, laws enacted by Parliament, statutory instruments, Zambian customary law, which is consistent with this Constitution, and the laws and statutes which apply or extend to Zambia as prescribed. The position that case law is a source of law is a principle of law. It is not contained in Article 7. So, principles of law, just like he's using this principle of law, are applicable in what we do, because this is what forms part of our training. And in our training, this is how we have come to the conclusion of what we do. So the law on paper and the law in practice are two different things. You cannot go and say, I will rely on this text. How are you interpreting that text? You will not find the literal rule in the Constitution. You will not find the mischief rule in the Constitution. But these are principles you use to interpret the Constitution. He can tell us if there's a text which says the mischief rule in the Constitution is this. There's nothing like that. But these principles are applicable. We can therefore not begin to argue any issue relating to the Constitution without applying the principles that help us understand these particular fundamental issues.
Let's pick another caller. Hello, good evening.
Hello, good evening.
Who's on the line, and where are you watching this program from?
Hello?
Hello, good evening. Are you able to hear me?
Yeah, this is Mr. Chinyama. Yeah, that is a cool voice of the name. Yeah. So, what I'm saying that Mr. Mark, the director, you think the director is explaining very well. Let us remove the political eye when we are talking about the Constitution amendment.
These some people, the schools of thought, people saying, no, it's not the right time to do it. We should do it after the elections. What do you mean? Because the UPND was given a mandate to rule this country up to next year, it is 2026. Meaning there's a lot of time to do the amendments. Some people are saying, no, they're supposed to do it first. How can they do it first if the country was paralyzed when the UPND came in? They had to do what's needful. Then we had the drought. They have to work on the debt restructuring. They have to work on unemployment level, which was too high. They have to work on free education. And now is the time to work on constitution. So why is the argument say, no, the UPND cannot do this now? They have to do it after 2026 elections. So you mean the UPND is not a government that can do everything, because the constitution amendment is a part of the UPND governance system. So where is the argument? They are saying, no, there's no money, you have to do other things than doing the amendment. If there's no money, why are we going for the election? Can we postpone 2026 elections? Is it going to make sense to you? So you see now, we are not doing a right thing, especially the PF did their amendment just the same year, the election year. And they did that amendment with some people were dozing throughout the night. Very unfortunate. And that this constitution that we have is very discriminatory. And also the Minister of Justice has said that people are free to air their views. They will be also be taken, their views will be taken. And those who, if they want to add some other things, they will add. So there is a consultation already in the process. So what's the problem? Just because it's coming from the UPND, then everything is bad? I think that kind of hatred is not going to take us anywhere. Let us support this amendment. It's long overdue, and it's the right time. Okay? I think I'm done.
All right, thank you so much for coming through, Mr. Chimo. Thank you so much for coming through. Councillor Malisa, what could potentially be the practical implication if we don't deal with the ambiguities in Article 52 before the next general election?
Okay, before I answer that, I just want to say that the question of Parliament having power to amend the Constitution is not in contention here. My brother Mark, it's not even in contention. No one is disputing that Parliament has got the power to amend the Constitution. No one is refusing. What we are saying is that there are principles that govern how an important document like the Constitution is supposed to be amended. The moment we start looking at the Constitution as any ordinary piece of legislation, then we already have a problem. Okay, I just thought I should make that very clear. Now, what are the practical implications of us going into an election without Article 52(6) being amended or without any amendment whatsoever? To me, where I'm sitting, and this is my personal opinion, I've already said that we had 2 elections with that Article 52(6) seated there, right? And the elections went on. They went on. So I will not believe anyone who would tell me that elections will fail to happen because we have Article 52(6) in the Constitution. No, that is not correct. And that will be, I think, will be tantamount to raising alarm in the public. So us as people who are trained, me, I'm not a politician. I don't come from a political party. I will not speak politics. He said that we should stick to the letter of the law. I'll stick to the letter of the law. The letter of the law, as this is that Article 52(6) has been there. It's not like it just woke up today and it just woke up today. Article 56 was there. I saw a problem with Article 52(6) and we took it to court. If another problem arises with the same Article 52(6), we will still take it to court. But to say that elections will not take place, I do not agree. Just to close and say that when a court is faced with a difficult question, like this question of Article 52(6), as Mark nicely said, that it has gone to the courts on a number of occasions. And I feel that it will go again if we have some mischievous politicians in 2026 who will try to use this to derail the democratic process. Right. When a court is faced with a hard case, there's a gentleman called Ronald Dawkins who writes a lot on constitutional interpretation. And there's a book that is called Hard Cases. It's a writing that is called Hard Cases. And it gives what courts should do when they are confronted with a difficult question like this one. And it says that judges have to find an interpretation that best fits the entire constitutional framework, right? And promotes the core values it embodies. So if it so happens that we have someone who tries to be mischievous next year, or it might not happen, like it hasn't happened in the last 2 elections, it has never happened. If it happens, we take it to court. The judges in the Constitutional Court, sitting in the Constitutional Court, have to interpret the Constitution in line with the entire constitutional framework. What is the entire constitutional framework? Zambians do not require every elections to be delayed just because someone has resigned. That is not what they want, right? So it would be irresponsible if our judges do not interpret the Constitution in such a way that fits the spirit of the Constitution or the constitutional framework provided for in the same Constitution. So the simple answer is, I do not see a situation where elections will fail to take place just because of one article in the Constitution.
Just as you respond to the issues there, Mr. Semue, on Facebook, Emmanuel Sianende says, directed to Mr. Semue, in the event that that the government's proposal to abolish filing in of fresh nominations in the event of a withdrawal, resignation of a candidate, death of a candidate, etc. goes through, as it is certainly most likely to, what remedy do you propose for the affected political party to ensure that the affected political party is not deprived of its constitutional right to participate in the electoral process? You have argued that the amendment proposals are non-contentious. Who decides what is non-contentious and what is not? In this regard, what criterion was used to come up with these proposals, only leaving out issues such as Bill of Rights? This is from Emmanuel Siende from Nsaka.
Okay.
Nimon Kadwele Chinda says, what would be the implication in 2026 presidential election if one candidate withdraws from the election after filing in nominations with current constitution?
Okay.
Francis Shikumulo says, can you kindly ask on my behalf whether or not the former head of state is eligible to stand as a running mate? Francis Shikumulo, do you have more messages? Do we have more messages? Okay, I think we've already read this one from Emmanuel Sainede. All right, Matthias Nyambazulu says, Parliament legislates on behalf of the people, but should those powers to legislate on behalf of the people be used without even considering the views of the people, not just selected people? All right, thank you, Matthias Zulu. Eyes Jackson Smaleka says, which people do you want the government to ask? Which government agency do you want to be on the front desk of amendment? Are those the only messages? All right, for now, those are the only messages.
So, I wanted to maybe
let me just also pick one more caller. Hello, good evening. Thank you so much for joining us. Hello, good evening.
Hello?
Tell us who is on the line and where you're calling us from and which platform you're watching this program on.
Okay. I'm watching it from Facebook. I'm calling you from within Nsaka. My name is Azamat Queen.
Okay. Please go ahead with your contribution, Mr. McQueen.
My contribution regarding the subject at hand is that there is no law, first and foremost, there is no law that has been breached by government in introducing this bill. That is settled. Now, when it comes to Article 52, the issue there is that we've already agreed, we've already seen that there's potential of having unnecessary court processes. So since you've already seen that there's that potentiality of unnecessary court processes, what this government has done is that we need to remove all those unnecessary battles that are supposed to be done in court. You remember the Chief Justice has guided that the court should not be used for political
should not be used as a ground to set to cure political problems. So in that regard, when you look at Article 52, the proposals that are in Bill 7, the proposals there are to strengthen our governance system and also to bring about respect to our court of law. So instead of having a plethora of cases, this provision, if it's there in the amendment, it will bring about an end to unnecessary politically inclined cases that go to court before the Constitutional Court. So that is the spirit behind this law. There's nothing behind it.
All right, thank you so much, my Queen Zaza Collins from within Nsaka. Your reaction?
Yeah, so my view is that maybe stemming from the comrade's submission with regard to what he believes as his personal opinion, which should be respected, where he believes that this same constitution, we have had two general elections under the same constitution. But again, he's forgetting that the judgment under discussion came way after these two elections. He has also admitted that after the judgment, it was now very clear that the people that drafted the constitution may not have foreseen a situation where we would get to where we are today. It is that kind of problem that has to be cured by legislation. And now, in this particular view, he's saying he does not agree, but he doesn't give reasons. If the court has made a ruling on a matter, even if he disagrees, what the court has pronounced will go ahead. And what is the pronouncement? Is that when there is a resignation, you go back. They are saying within 90 days, for example. What happens within the same 90 days if another person resigns? It means the same law will apply, which arises from the court judgment. Now, when you remain in that manner, with a judgment that allows you to go for fresh nominations after resignation, because the judgment does not state, if you have looked at the judgment, comrade, how many times candidates have to resign. Now, that is one of the issues that I think my comrade, the Queen Zaza, has raised. It is in the spirit of wanting to avoid unnecessary litigation processes. How are they arising? Malis has admitted, and how has he admitted? He said, should there be mischievous candidates, then we go back to court. Thomas Hobbes, in jurisprudence, a British philosopher, once said, we cannot rely on people's goodwill. Man needs some form of control. She was championing the importance of law in society. That's what he was trying to champion, that there should be some control through laws. So when he says, in case they are mischievous people, it means you are relying on people's goodwill. What kind of jurisdiction are we going to have if we are going to rely on the will of the people? Of course, in politics, people can be mischievous. So now, let me get to somebody who sent a text message, who is trying to talk about the Bill of Rights. That one is obviously a direct thing to do. When it comes to the Bill of Rights, you must have a referendum. And the processes of how it should be undertaken must be prescribed. So we cannot waste time on that one. But in terms of amendment, I think we remain to the text. No law has been violated. Outside what law has not been violated, we are discussing all these fundamental principles that are important. But then they cannot overturn what is expressly provided for. Then when we talk about, there has been insistence in referring to deriving the power from the people. Perhaps this must be addressed as well. Let me give an example of Article 118, and I quote, that's sub-Article 1. The judicial authority of the Republic derives from the people of Zambia and shall be exercised in a just manner, and such exercise shall promote accountability. Assuming that we underline the deriving of the judicial authority, at what point do we engage citizens? It is found in what my colleagues are championing, that justice should not just be practiced, it must be seen to be done. And then this particular article has outlined what exactly should be achieved. But the deriving from the people is basically in reference to the mandate given by the people of Zambia. Even when it starts and says, we the people of Zambia, it is the mandate from which is being derived. Then this particular constitution will establish institutions and vest the powers in people to exercise the powers on their behalf, including the president's roles. He will undertake all those activities and sign international treaties on behalf of the people of Zambia, from whom power is derived. That is the context in our understanding. Not that whatever you do, you go back to the people. Let me give you an example. So far, over 97 acts of parliament have been enacted. Can we tell the people how many people were consulted? It is because the power is vested in the legislature. No one was consulted. Over 97. And then over 500 statutory instruments. Nobody has been approached. Because there is no clear mandate in the constitution which is binding that they must go to the people. Those remain fundamental principles upon which constitutional making processes must be anchored. There is no argument on that.
And so you're trying to justify...
If there was, Andrew, by now, if the law was breached, there are two things that should have been expected. One, people would have rushed to the court so that the court can make a pronouncement that this process, one, is irregular. Number two, it's unconstitutional. And among many other reasons they can give. Secondly, it means the president and the executive are in violation of the constitution. Therefore, the people may want to obviously move an impeachment motion. But all those are remedies that are available. The question that you need to ask yourself, so that you understand the spirit in which our friends are debating, is what is stopping them from challenging the process?
Council, Simba, what is stopping you from challenging the process?
So let me first of all start by saying this. When we are dealing with the constitution, I think my learned brother Melissa did indicate that when we are dealing with the constitution, we are dealing with a totally different document. We refer to this as the grand norm. You can't compare the constitution to an act of parliament, because the act of parliament must be in conformity with the constitution. This is the foundation, it is the basis. So it can't be said that when an act of parliament is being enacted, therefore people must be consulted in the manner that the constitution is done. That is a flawed argument. It is an argument that cannot hold. But this particular document called the constitution is a document that requires you to go back to the people. It is not like an act of parliament where you go and just, if you want to doze in parliament.
And this question is that lawful?
The authority.
So,
in the constitution itself.
So in the constitution, when you look at the constitution, the constitution says, we the people.
No, but we
does
not say, come back to me.
He had an opportunity to
speak. Thank you. Okay. You have it.
So it says, we the people. Okay, so this is the people's document. This document calls the government to account. This document prevents the government from committing atrocities. That is what we have set as the people. The government cannot on its own just say, no, you the people forget, we are going to enact, and then they proceed. It doesn't work like that. An act of parliament, you can go on and do what you have to do with an act of parliament. We'll come and challenge it. I think the articles 60, 67 or so do provide for how you challenge those things and whatnot. But if you look at the constitution, have you come across any provision which will tell you to say, if there's this bill that is in place, you can go and challenge it at court? You can't challenge a bill. All we are saying is, yes, you want to amend the constitution. We are agreed on particular aspects that need to be amended, but not in the manner that you are doing it. Go. No. It's like I come and save you with nshima and beef, and I say I'm consulting you on what you want to eat. Would that be some consultation? It's not. What should be done is, before you come up with this bill, number 7, you must go to the people, collect views. And how you collect these views, we've done this before in this country. We've had the Monarch Catway Review Commission and many other commissions. You enact a piece of legislation, and that piece of legislation will then set the rules. That is when the Inquiries Act that he was talking about will come in. People will say, okay, we'll collect views according to provisions of the Inquiries Act, section so. And then you collect those views. That protects the views of the people. When those views are collected and protected, they culminate into a report. That report will then form the basis upon which legislation will be drawn, and that is provisions relating to from your views. Can we then consult? You can have public sittings, you can have everything else and go on. What is happening now is that this document has been published, but I have it on good authority that the Minister of Justice is actually touring the country and discussing this particular document. Now, these views that you want to discuss now, were they collected from the people in the first place? They were not. You have just given them a document out of what you think should be without any collection of views from them. And you want to now sit and let's discuss what I have given you. It doesn't work like that.
Councillor Balesa, I'm going to give you a minute or two to respond to some of the issues as you give your call to action. Councillor Balesa, your microphone seems to be muted. Are you able to hear us?
I had muted myself.
Okay, yeah. We can now hear you.
Yeah, I was saying there was a question which was directed to Mark there, that what remedy are you providing for the political party whose candidate has resigned? Does the political party go without a candidate? Now, let me say this. He will answer that. Mark will answer that. I also adopt that question to say, when you look at the content of the proposed amendment, it does not answer that question. So I don't know what the answer is. Maybe it should be fitted into the amendment as we are refining the bill. But what I will say is that former Minister of Home Affairs, Honorable Garen Kombo, not Home Affairs, sorry, local government, Honorable Garen Kombo once said, process protects the content. I'll repeat that. Process protects the content. Right. So when you're talking about a constitution, it is very erroneous to compare constitutional legislation to ordinary legislation. That is a very grave error. We have, for starters, the constitution is the supreme law of the country. It is not like any other law. It is a grand norm, as has been said. It comes directly from the people. It is the only law that comes directly from the people. It's the only one. So for you to say that ordinary legislative process follows, that is not correct. There is no other piece of legislation that requires a 2/3 majority to pass parliament. It's not there. Every other piece of legislation requires a 2/3 majority. That it requires an ordinary majority, but the constitution requires a 2/3 majority, right? That should tell you that the constitution requires more than just the arrogance of numbers that may exist from the ruling party. It is a bipartisan document. It is a people's document. It comes from both sides. To say that no law has been breached, that is very correct. And no one said that the law has been breached. No one said that. No one said that the law has been breached. There has been no breach of law. So to reduce this argument to a simplistic thing like saying we have not breached any law, that is diluting the gravity of the situation here. The gravity of the matter is that the Constitution is the most important law in this country. Hence the interest from almost everyone. Every other piece of legislation that comes, people, yes, they will debate, but with the Constitution, because the Constitution belongs to the people. So everyone has a right to talk about the Constitution. So to end this, I'll say, we have a lot of cases in Zambia where it has been said that you cannot equate constitution making to ordinary legislation. There are a lot of cases. I can tell you one, the most recent one. Law Association of Zambia and Chapter 1 Foundation Limited versus the Attorney General. This is I think it's the Bill 10 case. No, it's not Bill 10. That's 2020, judgment number 13 of 2019, selected judgment number of 2019 from the Constitutional Court. If I can give you the cause number, 2019 CCZ 0013. The court there, the Constitutional Court, clearly said that constitution making is not akin to any other piece of legislation. So it is settled law that when you're making a constitution, you cannot liken it to making any other act of parliament. Let me say this, you said I should, our call to action is that the government has already decided that it wants to amend the constitution. So the call to action, you asked me for a call to action. The call to action is, please open up the process to as many Zambians as possible and take on the views of the people, what they are saying, beyond what your predisposed position is, right? Number three, that I will say is that I think the time that has been proposed is too short for a consultative process. That's what I think.
Yeah.
It's too short. This is no ordinary piece of legislation. This is the most important piece of legislation. So if you genuinely want public participation, then it should not be restricted to just a month.
Yeah.
And it should not be restricted because the committees...
You've gone past your 2 minutes, Councillor Malisa. You've gone past...
I'll close. The committees sit here in Lusaka. The National Assembly is in Lusaka. There are people in Kaputa there who will not be able to come for those sittings. How do we cater for them? So if we're going to have an all-inclusive process...
Let me come to you. Let me come to you, Councillor Zimba, before I close off with you. Mr. Simue. We've agreed in principle that yes, there are issues that we need to work on in this constitution, and particularly, Article 56 of our constitution. Instead of us going back to court, back and forth to court, why can't we deal, with this? Provided now that we've been given an opportunity by government, to amend this constitution, as you give your call to action, Council.
We can deal with it, but it is the manner in which we are trying to deal with it. We have talked about issues of being consultative. We have talked about issues of finding middle ground. That has not been done. Let's do that and we'll get there. Coming to the call to action, I think if the government means well, let them withdraw this document. Why do I say so? In totality. Why do I say so? I say so because the rushed manner in which this particular process is being undertaken does not work well for the citizenry. This document is our foundation as a country, and we must respect that. We must respect the wishes of the people. Let us have this document translated into the many languages that we have. Let us have people give their views. Let's have wider consultation. And I think we will not have a problem with that. Above all, let us remove this aspect of politicians driving this process, because politicians have their own motive. Let us have a seamless process where citizens can participate nicely, give their views, and we have a process that is legitimate and there's consensus around it.
Mr. Simwe.
Let me start on this note that politicians are Zambian citizens. They are not excluded at law. There is no single law that excludes them from the process. Then the Constitution is a governance document. Okay, that is why when we say we the people, it involves even a child in Chibolia. It is not a document for a certain class of people. It's your document. Okay, so politicians are involved. You can never exclude them from the process because they are the ones who take the bill to Parliament. The ones who enact are politicians. So this is a contradiction to assume that politicians should not talk about anything. Meanwhile, you are taking it...
should not lead the process.
Let me finish.
I need to make that.
I'm concluding, comrade. I'm concluding. So, again, the same politicians are going to lead the process by way of taking it to Parliament until they enact it. Our mother and our father in Chibolia will not be there. Politicians will be there. The MPs that you take to Parliament to play their role under Article 62. The next point, when you say time is short from my colleague, there is no law that talks about time being short. First of all, the legislative mandate of Parliament is from the time of the first sitting when MPs are sworn in up to dissolution of Parliament. The 1991 Constitution, the CRC, was appointed in 1990. August 1991, the Constitution was enacted. In 1996, we had an amendment and we had elections. The Constitution that is forming part of this national discourse was amended in 2016. That's why it's called that was amended in 2016. Okay. The same year there were elections. And before 2021, 6 months before the elections, there was an attempt to amend the Constitution. So when we say it is too short, where are you drawing your authority from? Because the Constitution itself allows you to do that.
I'm saying the time frame. I'm saying the time frame.
But you've given your... I'm challenging your thought.
No, you're misquoting.
No, wait.
So that you respond correctly. I said the time frame for people to give their views is too short. I didn't say the time
Let me
frame
come
is
through. We've heard that argument before.
Proceed quickly as
Now,
well.
I think he's putting it in a good manner. People will listen when you do a repeat of the program. But so now, that's what I'm saying, that we've heard that argument before. Then when you assert that this constitution, okay, people must, the constitution prevents government from committing atrocities. There are no atrocities that were being committed, not even a single one. Again, we are agreed the constitution is the supreme law of the land. Then the next thing that obviously the two colleagues cannot disagree is that Article 79 provides for the process of altering the constitution. While those doctrines are fundamentally critical, they do not in any way extinguish the provisions under Article 79. In other words, we are still within the constitutional mandate of legislating. And when you draw your mind, direct your mind to Article 62, it is immaterial under that article on what legislative power is being referred to. It is both the supreme law and any other piece of legislation. I thank you. So, the actionable part is that this particular document must go ahead. People have no legal basis for us to stop the process. That is why we have completed close to 1 hour 30 minutes. Our colleagues will not tell you a single law that has been violated or breached, and they have demonstrated and they have admitted. What they are driving is a moral argument.
UPND Media Director Max Mowe, Constitutional Lawyer Meluli Malisa, Constitutional Lawyer Jonas Zimba, thank you so much for making time to discuss this very important document on the program across 6 TV stations tonight.
Cheers.
We'll be live on Power TV, that's on DSTV channel 278, Go TV channel 19, on Diamond TV we've been live on channel 271 and Go TV channel 20, on KBN we've been live on DSTV channel 279 and Go TV channel 27, on Topstar channel 102, on Musanza TV we've been live on channel 93, and on BIS TV Topstar channel 92. On behalf of the entire production crew, thank you so much for watching. My name is Andrew Mwansa. Next week we discuss the cybersecurity and its implication on the freedoms of our people.
Class, what is 9 times 9?
Teacher me.
Sammy, 9 times 9.
When the belly's rumbling, hunger's coming, Uncle Joe will give you something filling with a natural flavor. Uncle Joe is in there. Shaky Joe. Shaky Joe, fill yourself with goodness.
Great news! What if we told you that you can get more than what you paid for?
This war has just begun.
and you can explore a whole world of entertainment waiting to be discovered. With GoTV, you can now enjoy so much more entertainment for you and your family.
Palmer, Lavia back in, Jackson!
Because when you pay for GoTV value, you get GoTV Plus. When you pay for GoTV Plus, you get GoTV Max. When you pay for GoTV Max, you get GoTV Super. And when you pay for GoTV Super, you get GoTV Super Plus. All on us for no extra kwacha. So get Bevla on us. Pay for your current package and get upgraded to the next higher package. You can also enjoy this offer on the go with GoTV Stream. This is a limited time offer.
Romeo, yeah, te kubraga ninterera, nimpo boga kumwera kumkanda. Mutukulele maskini ruti nimbekere ngentanda. Sikiri tini Romeo, pure glycerin, idionse muchipi. Mild and gentle, protect your skin, it's affordable. No crack pankandana. Romeo, nitela skin tonina. Romeo, soft and tender. Romeo, shamona po glycerin better than Romeo. Kopala queenie. Romeo, I'm a bit of pew queenie. Romeo, Saven. Romeo, Fenta no Fenta.
To know where we're going, we must remember where we're coming from. Boom. Never